Good afternoon, everybody. So today's topic is the most recent case law from the court. So this is all 2021 case law, so, right up to date. What I'm going to do, as with quite a lot of these webinars, there's a lot of information on the slides. I'm just going to go through and summarise the key points in the cases. So how I'm thinking that this might help you is that, first of all, this is the case law at court. Now, obviously, most people don't want to be going off to court every so often, but this is the case law that the adjudicators will apply if you're in adjudications, but also probably more relevant to you if you're in negotiations or in discussions of any sort. So you're negotiating your contract, you're negotiating a settlement, or you just need, for whatever reason, to know what the legal position is. This is the case law that you need to know about. Now, some of it segues nicely into this Balfour Beatty and Van El case, probably or hopefully reinforces what you understand the position to be. So, Balfour Beatty, well-known main contractor, and Van El, well-known piling contractor, subcontractor. And a lot of the themes that this case takes in, you will be familiar with, I think. So here, Balfour Beatty were the main contractor, and they engaged Van El to carry out some piling. So no surprises there. Initially, Van El were engaged and carried out the vast majority of its works based on a letter of intent which incorporated Van El's own terms and conditions. Now, hopefully you will know that when you start work on a basis of a letter of intent, the intention always is to enter into what I tend to call the main contract later on down the line. The letter of intent is a temporary solution until this main contract has been negotiated. As I've said, what happened here, as often happens, to be frank, pretty much all of Van El's work was carried out with this letter of intent being the contract. The main contract was entered into later on. After completion, unfortunately, Balfour Beatty found defects in the piling which required remediation. So the issue was, if Van El was liable, could it use a limitation of liability that capped its liability for defects, and which was in its own terms and conditions, but not in the main contract that it had entered into after the work had been substantially carried out. And why I say, this sort of reinforces generally what we know the position to be. The court held that actually the liability was determined by the main contract, or it's called in the slides a subcontract, that had been entered into, and not the letter of intent and Van El's standard terms and conditions. So Van El didn't have any any cap on its liability, except whatever was in that main contract. So, as I say, that should probably be your understanding of the situation. And at these webinars and seminars, I always talk about, if you start work on a letter of intent, make sure any cap in your liability is included in it, so that it can go seamlessly into the main contract when that is signed. But also make sure that main contract gets sorted out and executed as quickly as possible. The next case is Mansion Place and Fox Industrial Services. So this is all about oral or verbal settlements. Anything verbal, is going to be problematic, because the problem is you have no evidence that it happened except your word against the other parties. So what had happened here was the parties were pretty much in a dispute over, kind of the normal final account issues, and particularly extension of time and loss and expense. This was on a JCT contract for the contractor and the employer who wanted to claim liquidated damages. So again, a fairly common scenario. The parties, or two individuals on behalf of the parties, had a phone conversation with regard to these claims. The upshot was that Fox argued that a binding drop hands agreement had been reached. So basically, each party agrees to drop their own claims and walk away. And Mansion disputed this and started an adjudication. Now, obviously, if the matter had been settled, as Fox argued, there's no dispute, so you can't adjudicate it. So the matter had to go to court to determine whether that agreement in between the two parties, when they had that conversation, this drop hands agreement, had agreement been reached. So I think the moral of the story here is put your agreements in writing. If you have calls like this, put something in writing afterwards to record it. You're not what goes in writing after the agreement's been, reached verbally is not, this is the agreement. It's all you're doing is recording what the agreement is, and it's effectively giving the other side the opportunity to say, hang on a minute, that's not what we agreed. The other thing is, when you're having these discussions and reaching agreements, I always think it's good, you have the discussion around it and the arguments, and sometimes gradually the agreement evolves from that. And I think it's always good, quite often people are keen to move on to the next item or end the call and get on with something else. But I think it's always good just to backtrack a bit and say, right, so we've reached an agreement, just to confirm these are the terms of the agreement, drop hands deal, is that right? Is that correct? And it just gives everyone that opportunity to say, yes or no, depending on, whether they think there was an agreement. And I think if you've done that, it then becomes very difficult if an agreement has genuinely been reached, for one of the parties to come back at a later date and say, actually, there was no agreement. So, as I say, the court had to decide, was there an agreement, one party's word against the other? And the court said, yes, there had been agreement. There'd been offer and acceptance, and the parties were wanting to do a deal. So there was intention to create legal relations. The court also looked at the wider facts. So things like the fact that the evidence showed that each party had made their respective claims in writing previously. It showed that they were having a discussion about it, and then it seemed logical that they then have a discussion, and a settlement has been reached. There was also evidence to show that Mansion, the client, the employer, was worried that Fox, the contractor, would leave site. So, they needed to come to a resolution to this issue. And of course, evidentially, had an agreement not been reached, Fox was saying they would be leaving site, and they didn't. So logically, it seems as though some sort of an agreement had been reached. So in this case, the court did find that there was an agreement. There are no guarantees that the same would happen in a different situation, because the court will be looking at the wider facts and hearing the evidence of the parties who made the agreement. So, that's why it is so important. It's important to have these discussions and reach agreements, but you either then confirm the agreement in writing, or when you're having the discussion, say, look, any agreement we reach now is subject to a written contract, so that a written contract then has to be prepared and signed, and it's only when that signature is on the agreement that it's actually binding on the parties. Next case, building design partnership and standard life. So this is a case about sampling, which I think is quite interesting. So in this case, spoiler alert, the court said that in a negligence claim, sampling was allowed. So what happened here? It was quite an unusual scenario. And sort of the facts, I'm just giving you the facts so that you kind of understand the context. But I think this sampling issue might be helpful in kind of account disputes, particularly, say, framework disputes on framework contracts. So in this case, one party was the contract administrator, and the developer, so BDL was the contract administrator, and Standard Life were bringing proceedings against them for basically badly administering the contract. So what Standard Life was saying was, BDL, you were administering the contract, you were the contract administrator, and you allowed all these variations which should not have been allowed. And therefore, we, Standard Life, have had to pay out far more money than we needed to. Now, what Standard Life did was they analysed a sample of 167 of those variations. It's a really odd number. There were a total of 3,604 variations. So this was a busy project. So in the 167, I think it comes to about 4.something%. So I'm not sure why 167. If I was going to do a sample, I would tend to pick, say 5% or what I thought was an appropriate figure. But anyway, they took 167 as a sample and asked the court to extrapolate that to apply to the 3,604. For obvious reasons, the Building Design Partnership disputed this and said that they had to go through each and every of those 3,604 variations and prove that each one of them should not have been granted by BDP as contract administrator. Surprisingly, in a way, the court held that it was, so this is the second bullet point, it was disproportionate for Standard Life to go all the way through the 3,000 and odd variations, and therefore accepted in principle that sampling was acceptable to prove the full claim. However, it's not as simple as, well, I'll prove 2 of my variations and let's extrapolate that result to the rest. Because what the court said was that Standard Life would need to prove that it was reasonable to do that extrapolation. So reasonable to draw an inference that the allegations detailed in that 160 odd claims and what was proven in those 160 odd claims could be extrapolated into the 3,000 and odd claims. It helped here that Standard Life had expert evidence that supported not only the 167 claims, but looked at the extrapolation and explained why it was reasonable for that to take place. So, if this isn't an easy way to avoid having to deal with the difficult claims, or well, we'll just deal with the easy claims and ask the court to extrapolate the results. It's not that by any means, because you do still need to go through some hoops to show that it is reasonable to make the extrapolation. But in cases like this, and that's why I'm thinking of framework contracts, it could be the case where, you just plead to a few particular claims and basically then show that the remaining ones are so similar that you can do that extrapolation. So the next case is BT Passive Norse and Canham Consulting. So this isn't, I wouldn't say this is particularly new law. It relates to causation, and why I've included this is, obviously it's 2021 case, so it's very recent. But it is a reminder to all of us that causation is important in construction claims. Now, this claim is all about defects in a building, but the causation point applies equally to a compensation event, a variation, change of work. You've got to show that the change that was requested caused the works to be changed, which caused the quantum that is claimed by the claiming party. So it's a similar principle. So in this case, the claimant, which was BT Passive Norse, made a claim against Canham, who was the consultant engineer. What had happened was that there were design defects in the foundations of a row of new terraced housing. It was really unfortunate because the defects had resulted in BT Passive Norse having to rebuild the whole row of terraced housing. So, of course, this was a big claim because it was a lot of money. What happened with the engineering consultants, Canham, was that it admitted that it had been negligent in some aspects of its design of the foundations, but it said that there was no causal link, so there was no link to its negligence, the defects that it caused, and the requirement to demolish the whole the whole block of housing. And the court found in favour of the consultant on this. It said that the contractor BP had failed in terms of causation because it hadn't shown that the demolition had been required because of Canham, the engineer's defective design, or that the demolition was reasonable. So the court didn't even accept that it had been necessary to demolish and rebuild. It wasn't quite as simple as that because it transpired that BP, the contractor, hadn't given its subcontractor carrying out the groundworks the most recent of Canham's engineering designs, and also that the construction of the blocks themselves were defective in any event. So essentially the court found that the engineer's defects, the defects that were caused by the engineer's negligence, could have been remedied without the need for demolition. The requirement for demolition, if there was one, and of course the court wasn't even satisfied that demolition was required, but if there was a requirement for demolition, it related to other issues, and in particular the groundworks subcontractor working to old versions of documents. So that's the issue on causation. I would say, in terms of defects, this is very much my experience of how defects arise, unfortunately. It's often not, really difficult technical issues. It's often caused by just a lack of communication between the parties, so the consultant, the contractor and the subcontractor, and very often, you see the designs being emailed to the subcontractor. These are important designs emailed to the subcontractor, Sometimes there is an error, as in this case, Canham accepted some of it was negligent, but that was exacerbated by the fact that the wrong design was sent to the subcontractor. And I think on some circumstances, I know cost doesn't always justify it, but in some circumstances, getting into a room, all parties and, discussing what is going to be passed to, the ultimate designer, discussing it with them and talking it through, is sometimes really helpful and can avoid these problems. This next case, Triple Point and PTT, this is about liquidated and ascertained damages or delay damages. So if we take a step back, first of all, what are liquidated and ascertained, or liquidated damages, or delay damages? They're all the same thing. Effectively, they're generally used in construction contracts for delay. The fundamental principle in contract law is that if one party has an obligation, so in this case, an obligation to complete by a set date, if they don't complete by that set date, then it's a breach of contract. And if you're in breach of contract, you've got to pay the other party the losses that flow, the reasonable losses that flow from that breach. So without liquidated damages clauses, you would be paying, as a contractor, you'd be paying the client, the employer's losses flowing from that delay. So there may be, loss of income, etc. Now, the employer, the client, would have to prove that loss of income. So to avoid or cut out a few of those steps, we basically agree at the outset of the contract what the damages are going to be, which means that the claiming party, the client, doesn't have to prove its losses because we've already agreed them, they're in the contract. And also the contractor or the paying party, knows the extent of its risk in terms of the quantum. So what happened in this case, and I mean, this went through 3 courts. It went up to the Court of Appeal, which is why, you might have heard of it because everybody got very excited about it, or all the lawyers did anyway. And there are a number of scenarios. So the first one was, and it's the second bullet point, the contract had some slightly odd wording because it said that the LADs, liquidated and ascertained damages, would accrue per day of delay from the due date of the works until the date that PTT accepts the works. So it's that bit that's underlined is a bit odd. Why would it only accrue until they've accepted the works? So the issue there was, did that wording really make any difference? And the court said basically no. It was that the liquidated damages were payable for so long as the works hadn't been completed. The next issue was the contract was terminated before completion was achieved. So the issue then was raised, well, how long can we claim the liquidated damages? Can we claim them up to completion? Because by that point, if the contract has been terminated, that contractor isn't going to complete. It's going to be a third party who'll complete the works. So can you continue to claim liquidated damages until a third party's completed, where the original contract's been terminated? Or can you only claim liquidated damages up to the point of termination? And the court found that it was that latter. You can only claim liquidated damages up to termination of the contract. After termination, the claim is for general damages, so damages that you've got to prove your losses. and the and yeah, so the other point here is that, you know, as I said, this matter went up to the Supreme Court, and at each stage, so it went through 3 courts, and at each stage the court found had a slightly different answer. So in some respects, you know, I don't think what the courts found with regard to liquidated damages, I think particularly the termination point is of interest, because, you know, it was always an issue that hadn't been determined. But I think one of the issues here is, you know, the fact that you can go through 3 courts and get 3 different answers. So in a way, it's an argument for trying to negotiate resolutions to disputes rather than going through the courts and expecting to get, you know, a specific answer. This next case is also about liquidated damages. So this is EcoWorld versus Dobler. This is around, and we're actually seeing the liquidated damages topic has been, you know, quite prevalent in the courts over the last few years. And one point that I should have mentioned about liquidated damages is that once the liquidated damages figure is in the contract, if a dispute arises later on and the party who has the benefit of the clause, so usually the client, the employer, wishes to levy the liquidated damages, the contractor can, or in the past has been able to argue that the clause, if it was a penalty, so if the amount was, you know, a penalty rather than a reasonable estimate of the loss the employer might suffer, that clause basically would be struck out and the parties would revert to general damages, where the claiming party would have to prove their loss. Back in 2017, a case went through the courts where the courts tightened that up and basically said, look, you know, we don't want to be looking at these penalty clauses. If contractors sign contracts that contain an amount in them for liquidated damages, you know, then we are generally going to say that is the right amount because they've signed up to it and they didn't have to if they didn't want to. So it's basically reduced your opportunity as a contractor to contest these liquidated damages figures as a penalty. So this EcoWorld case, what was this about? Well, typically in a construction contract, so for example in JCT, there will be a provision that says so this is ignoring any sectional completion, if the employer takes over all or part of the development, the works, before issuing completion certificate, then any liquidated damages that the client, the employer, is entitled to claim after that takeover, so it's an informal takeover, any liquidated damages that they levy after that takeover must have a reduction based on apportioning the liquidated damages as against the proportion of the works that have been taken over. So if client takes over 75% of the works today and wants to claim liquidated damages next week, they can only claim 25% of the sum that is in the contract. Because they've taken over and they've got the benefit of 75% of the work. So I hope that's clear. Now, the problem in this case, it was a bespoke contract and it didn't have that clause in it. Now, you know, it's a standard clause in all the standard forms of contract because it's only fair, it makes sense. There are a whole host of reasons why, you know, contracts do not generally exclude that clause. So the paying party went to court to say, that clause should have been in, it's a reasonable clause, it's a fair clause. So, we want that clause including, and we want the liquidated damages apportioning. And in line with the case in 2017, the court said, no, you didn't include that clause in your contract. If you'd wanted it in, you would have put it in the contract. So we are not going to apply this clause. It's not in the contract, so you cannot benefit from it. So be careful about that when you're entering into bespoke contracts. Make sure there is a clause in that allows the apportionment of the liquidated damages if, in the event that the client, the employer, takes over a part of the works. And also in your JCT, in your NEC, in your in your standard contracts, ensure that that clause isn't ever removed. It's really rare. I can't remember having seen it being removed, but just make sure that it's really important that it is in the clause, so in the contract. Next one, CC Construction and Rafael Mincio, another 2021 case. So this is a JCT contract, and it's all to do with the final account in JCT and the fact that the final account has, the JCT has provisions which allow the final account to become conclusive between the parties within certain timescales, unless one of the parties challenges the other party's final statement. So this is a really harsh clause. Generally, JCT, unless it's amended, doesn't contain these kind of killer clauses where unless you operate it, you're stuck with it. So basically, it means that if you're a contractor in the JCT and the client submits a final statement, presumably submits it for the sum certified so far, which may not be the sum that the contractor wants to be paid, because usually by the final account there is a bit of a delta, and the contractor wants to be paid more than it has been paid. But if the employer submits the final statement, then that becomes final and conclusive within the deadlines, and it's in that third bullet point. So it becomes conclusive 1 month from the later of, so it's the last one of the end of your rectification period, the date stated in the notice of completion of making good, and the date of the submission of the final statement. Excuse me. So effectively, if the employer has submitted a final statement during the rectification period, the contractor just needs to be really careful, because that is going to become final and conclusive, i.e. you cannot adjudicate it and you cannot go to court to dispute it. It becomes final and conclusive 1 month from the later of the final statement, so we know that's already been submitted, the end of the rectification period, and the date of the notice of making good. So typically, if the final statement has been submitted during the defects period, the latest date is typically going to be the notice of making good, but that is something that the contract administrators issues. So contractors have no control over that. Ditto, they have no control over the end of the rectification period. You need to be careful, because once that time has expired, it becomes final and binding and you can't dispute it. So you need to be ready, and you need to be thinking about this during the rectification period, getting together an adjudication so that you are ready to dispute it. And preferably, you need to be adjudicating it before you get to these timescales. Now, this case concerned the issue of, had it become final and conclusive because the final statement had been submitted, but there was no notice of making good defects. The court said yes, the it had become final and conclusive. And the reason for this, and again, you need to be careful with this, that what the court said was that because during the rectification period there had been no notified defects, that meant that the notice of completion of making good defects wasn't required. So it effectively removes one of the criteria in that third bullet point. So if you've got no defects during your rectification period, then it's going to be conclusive, assuming the final statement has been submitted during the rectification period, then it becomes conclusive 1 month after the end of the rectification period, because you need to ignore or pretty much remove that requirement for a notice of making good defects. So again, just be really careful about that. Toppen and simply construct. So this is all about a collateral warranty and whether it's a construction contract. So why is that going to be relevant to contractors? Well, there are a couple of points here. So first of all, what's a collateral warranty? If you enter into a contract with a developer as a contractor to build a block of to build a block of offices, typically that developer will be planning on selling that block of offices once it's complete, possibly to a pension fund, possibly they might give long leases to occupiers, etc., etc. But the chances are that the developer will not be hanging on to that property for a long time. You probably know, if you come to these seminars, that generally contractors, parties to construction contracts, are going to be liable for defects for probably 6 years, generally 12 years. So that's a long time. A property can go through several ownerships during that period. So what happens if you get to the third owner, property was completed 6 years ago, there are defects? How can that third owner pursue the contractor for damages to remedy those defects? Well, the answer is they probably cannot, unless they've got a collateral warranty. So that's why collateral warranties are really important, because it allows subsequent parties to pursue for defects. Now, from a contractor's perspective, it probably doesn't matter, because it doesn't mean contractor's going to be responsible for two parties. It's only ever going to be responsible to pay one party damages for defects. And obviously, the employer is now out of the picture. They haven't suffered any losses, so they won't be making a claim. So the collateral warranty is a contract, and it's signed between the two parties, so the contractor and the new owner, and it's to make sure that the new owner can claim for defects. So usually in your construction contract, it will say contractor is required to enter into a collateral warranty with any future purchasers, and that's why it says that. So that's collateral warranty. What's the relevance of construction contract? Well, the Housing Grants Act allows parties to a construction contract to adjudicate their disputes. So adjudication is bespoke to the construction industry by an Act of Parliament, but you've got to comply with the Act in how it defines a construction contract. So, for example, building a house for a homeowner, so not a house builder, but, if a construction company builds a house for me, that's not a construction contract. So some, construction contracts, some contracts that are for construction are excluded. That's to protect, the homeowner, because they would think, well, somebody like me having a house built wouldn't really know too much about construction. So it's unfair for them to have to, get embroiled in, all this stuff about adjudication, which they won't know about. So the issue has arisen on several occasions as to whether a collateral warranty is a construction contract. Now, why it's important is that it's not important for contractors, because usually the contractor wants to adjudicate to get its accounts sorted out and paid. Well, it will adjudicate its client, the employer, for that. Where it is important is for those future purchasers who possibly discover that there's a defect and want to adjudicate to get the damages for that defect, rather than going through court proceedings. So that's bad news for a contractor and bad news for the contractor's professional indemnity insurers. So you really do not want your collateral warranties to be construction contracts. So this is just one of several cases that is looking at, is a particular collateral warranty a construction contract? So one thing when you're looking at your collateral warranties, and remember they typically will be appended to your main contract, the contract that you sign with the developer, with your client. What we might start to see as a result of this case are clauses that actually say the two parties agree that the Housing Grants Act applies and that this is a construction contract, and therefore the parties can go to adjudication. So if you see anything like that, that needs to be deleted. You don't want that clause in your contract, because that is to protect future purchasers so that they can adjudicate for defects. It's not, and all you're saying is, no, I don't want you to adjudicate. It doesn't mean that they can't go to court. What happened in this case was that the collateral warranty was produced after the works had been completed. And what the court did was that they looked at the timing of when the collateral warranty was produced. So if your warranty is produced after you've completed your work, then the suggestion there is that it's not a construction contract. It's a contract that records that construction work has been carried out, but it's not a contract for construction works. And they also looked at the wording, so things like talking about, let's see, I think we've got the wording somewhere, where you're talking about a clause to say the contractor has and will carry out the work with reasonable skill and care. So it's that "and will" is really important. You don't really want that, because that's suggesting, and of course, we've seen from other cases today that the courts look very carefully at the wording. And if your wording says that you have and will carry out the work with reasonable skill and care, you have and will, employ, use good quality materials, you have and will continue to. It's that "and will continue" suggests that the work is ongoing. Even if it isn't, it's the wording in the contract that the court will look at. And on this one, the court said that on the specific facts, it did not consider this one to be a collateral warranty. But, for you guys, you just need to think about those 3 points. First, that there absolutely isn't a specific clause in to say it is a construction contract, or it can be adjudicated, or that the parties agree that the Housing Grants Act applies. So definitely not that. You definitely do not want clauses that indicate that you've got a continuing, an ongoing obligation. So it should all be past tense obligations. Excuse me. The contractor has exercised reasonable skill and care, not and will continue to. And also the timing of it is helpful. Now, with some of them, you can't help the timing of it. So, for example, typically funders will want a collateral warranty, but they'll want it pretty much as work starts on site. Whereas, future purchasers, obviously the timing of that is going to be typically, at a minimum as you achieve completion. It might even be later than that. So just bear that in mind. Right, next case, transport for Greater Manchester and Care Construction. So this is just a case about serving notices. So it's a bit of a dull topic, to be honest. But I wanted to talk about this. So this is an NEC case. And the rule is under NEC that you've got to adjudicate any dispute before you go to court. That's an absolute must. And also there's another absolute must, which is once you've adjudicated and you've got the adjudicator's award, if you're not happy with it and you want to go on and get the court to determine the issues, you have to send what's called a notice of dissatisfaction to the other party. And you've got to do that within 28 days of the date of the adjudicator's award. If you don't do it within that timescale, then you are deemed to have agreed with the adjudicator's award, and you cannot then go to court to get the court to redetermine it. So it is a really important document. And it is a formal notice. So, there is always, it's always worth thinking about whether, you can dispute whether that notice is valid, either because the content makes it invalid, it doesn't contain the right information, or because it's not been served properly. So it's been served by email when it should be served by letter. It hasn't arrived within the 28 days because it was posted within the 28 days, but didn't arrive for several days after. And critically, most construction contracts, that includes NEC, it includes JCT, state how notices are to be served. So, for example, JCT, I'm trying to think if JCT does. Typically, JCT says, I can't remember now whether this is an amendment or the standard JCT, but typically it will say notices served by post, and irrespective of receipt, they're deemed to have been received within 2 days of posting, providing they're posted. I think it's either special delivery or the other one. It's one or the other. So you've got, so if you just email it under JCT, you're never going to serve your notice properly. So you need to be careful about that. What the arguments in this case were that first of all, the notice, the content wasn't correct, because the other party said you had to plead your case fully and properly and what bits you disputed. But actually, if you read the NEC, it doesn't say that. It says, it's just quite vague, and it says you've just got to state that you dispute the adjudicator's award. So the court said, so this is the third bullet point, that because there was no prescribed form of words required by the NEC, the notice, it was clear what the party intended. They didn't agree the adjudicator's award. You don't need to go into lots of detail. Having said that, if you are issuing it, I would probably ask a lawyer to have a look over it and check it. The other issue was as to the notice was served on the other party's solicitor who'd acted in the adjudication. So they said, well, they weren't, the notice should have been served on the parties in the contract. The court looked at that and said, well, no, because when the parties' solicitors were corresponding, they were both saying, look, we act generally for this party in relation to this matter. So that was sufficient to cover the notice of dissatisfaction. But again, probably at this stage you do have a lawyer involved, but it's a salutary lesson for your project management. If you are told serve notices, if you're told in the contract to serve notices on one party, but you are then told, oh, it's a different party, you need to make sure that you're serving it on the right party. And the court also said, so this is the final bullet point, that, the notice was sent by post, but it was also sent by email. So the postal service was fine, but the court said that they weren't happy with email service under the standard NEC form of contract. So that is just something to be aware of. I think that's the biggest problem for us, in that effectively it was saying that you have to have postal services of notices. That's notices generally, not just this one, for NEC. So finally, I just want to mention 3 quick cases. FCA and ARC deals with an insurance claim, which is why I'm not looking at it in detail, but it's to do with COVID loss of business. And it was quite generous to the claiming party, so the party who was impacted by COVID. So, it's just one to bear in mind if you are making claims based on COVID at all. The next one, Banord and Dragados, NEC 3 case. We've had this is part of a long-running saga, so there have been several court judgments on this one. And basically, the first one, the contract was terminated. Sorry, no, the part of the work was removed from the scope of work. But the contract said the scope could only be removed if the parties higher up the contract chain removed that scope. So the court found that the scope had been removed in breach of contract because there was no authority to remove scope because they hadn't complied with that contract. So then the next case went on to look at valuing for removal of the scope. And what the court said basically was, this is a compensation event for breach now because they weren't entitled to remove the scope, and therefore it would be valued in a different way to the normal NEC way of valuing. So that's just worth bearing in mind in circumstances where you have a compensation event that is a breach, which is a compensation event under NEC, of course, and if you have a removal of scope and how to value it. Finally, John Doyle and Erith. So this is relevant for adjudicating when insolvent. So I would imagine it's typically relevant to you where perhaps you were a contractor in a project and possibly the subcontractor went into liquidation. Subcontractor then tries to adjudicate, and typically up until now, subcontractor would have been able to adjudicate but wouldn't be able to enforce that award if the award required the contractor, in this instance, to make payment, because the courts say, well, that's not fair because the subcontractor is insolvent, so we can't have a temporary payment, because technically that's what adjudication is, a temporary payment to an insolvent party because those assets might be dissipated. With this case shows that the position has slightly evolved in that the courts are now saying, well, if the subcontractor, in my example, does adjudicate and all issues relating to that account and anything else can be dealt with in that adjudication, so it resolves everything, or everything is dealt with, then it will be enforceable. Now, probably that doesn't help the subcontractor if, for example, there are several contracts that between the parties and set off clauses between them. Also, it doesn't help, for example, if the contractor has a counterclaim that is, bigger than the sum that the subcontractor is claiming from. So again, I just wanted to mention that. Probably again, by the time you get to this stage, you've got your lawyers on board, but it's just a point to note. If you are getting parties who are going into liquidation partway through a project. So I think that's everything for today. My contact details are there if you want to ask questions and haven't got time now. Absolutely amazingly, I've finished at dead on 2. It's only taken me over 2.5 years of webinars to do that. But any questions now, happy to deal with them.
I think, Sarah, somebody's adding something now.